Good morning, everyone. Thanks for joining us. I'm going to wait another minute or two so that way people can get situated and more folks can join in. Thanks for your patience. Good morning and welcome to the webinar, Community Health Choices After Continuity of Care, What Phase 3 Participants and Their Advocates Need to Know. I'm Kayla McNally, the Communications Associate at the Pennsylvania Health Law Project, and I'd like to quickly go over a few items so you can participate in today's event. You will have the opportunity to submit questions to the presenter by typing them into the Q&A pane of the control panel, which should be at the bottom middle of your screen. You may submit your questions at any time during the webinar. We will stop to answer them around at the end of the presentation. Please note, a brief post-webinar survey will launch after the webinar concludes. It should take about 1 minute to complete. If you have technical difficulties at any point, please hang up and dial back into the webinar. If the problem persists, you can email me at event, E-V-E-N-T, at PHLP.org. And now I'll turn it over to our presenter, Janice Meinert.
Thanks, Kayla. Good morning, everyone. Thank you so much for joining us today. I hope this information will be helpful. As Kayla said, please don't hesitate to send any questions in on the Q&A feature. The more interactive this is, I feel anyway, the better. I just want to start by letting folks know, and Kayla already mentioned the survey that she'll be sending at the end of the webinar. This webinar and a lot of the work that we do at the Health Law Project regarding community health choices is funded in part by a grant from the Pennsylvania Developmental Disabilities Council. And so one of the requirements, and as you can see on the screen, that's tied to federal dollars that then flows down to the state. And one of the requirements from the federal level is that when we do any kind of education, presentations, webinars like this, that, that we survey the folks that participated. So again, we really appreciate it. It truly is a 1-minute survey. I think there are 5 questions, excuse me, and if people can take the time to answer them up, I really appreciate it. And the council appreciates that as well. Okay, so I want to spend a few minutes talking about the Health Law Project. For folks who may be joining us today and aren't familiar with us or don't know, have a good sense of just what we do and how we can be a resource to individuals and people who work with folks in Pennsylvania. So Pennsylvania Health Law Project is a statewide nonprofit law firm, and our work focuses on helping people access public health insurance or coverage and services through those public health insurance programs. So when we say public health insurance, we're talking primarily about Medicaid, what we often refer to in Pennsylvania as medical assistance, CHIP, the Children's Health Insurance Program, Medicaid waiver services, which of course is a big piece of what we're going to talk about today. And also to some extent work with folks on Medicare, in particular low income Medicare beneficiaries and people who have or may be eligible for both Medicare and Medicaid. So the primary way we help folks is through our helpline, and you see the number on your screen on the PowerPoint. Our helpline operates Monday, Wednesday, Friday from 8 a.m. until 8 p.m. So those are the only times people can either get through live to our intake paralegal or leave a message. If you call outside of those days and times, you just get a message letting you know that you have to please call back during those hours. Anybody can call the helpline, so somebody can be calling on behalf of themselves, their kids, their family, social workers, doctors' offices, anybody can call the helpline. Our services are all free, whether we're providing advice or maybe just brief services to somebody, or actually providing legal representation. And we'll talk more about that as we go through the presentation and give some at least CHC related examples about how we can actually represent individuals in appeals. We also do, a good bit of what we're doing today, community education, trainings. Unfortunately now everything's pretty much remote and by webinar, but we also do a lot of in-person when COVID isn't impacting all of our lives. And we create a lot of self-help materials. Our website, and I apologize it's not on here, is PHLP.org. And so you can find lots of information about lots of Medicaid related topics, some Medicare topics. There's a lengthy manual on Medicaid home and community-based waiver services. So lots of good and hopefully helpful materials on our website. We also do a monthly e-newsletter and that people can receive electronically. If you'd like to get that, then please, you can email me directly, that's fine, or just email staff@phlp.org. Let us know your name, your email address, and you will, start receiving, as of September's newsletter is in the works as we speak. And then from the direct client work that we do, that really feeds the bulk of our policy advocacy. That happens primarily at the state level with the state officials, responsible for, the Office of Medical Assistance Programs, the Office of Long-Term Living, the Office of Mental Health and Substance Abuse Services. So we see issues come through our helpline, and from there we, identify what might be a potential systemic issue, specific maybe to one managed care plan or specific to, a broader piece of the system, and then work with those state officials and with consumers and state officials to try to improve and shape the Medicaid programs. So, and any questions about, who we are, what we do, our work is very specific around the public health insurance. So unfortunately, we don't help people with things like SSI denials or, housing issues. It's very, very specific to, Medicaid, CHIP, Medicaid waivers, low-income Medicare beneficiaries. So any questions about that, please just, send that to me or to, to the Q&A box now. Okay, so what are we going to talk about today? I'm not going to read through that agenda. Folks can see it, but we're going to, talk about CHC. We're going to talk about waiver services really exclusively under Community Health Choices, and talk a good bit about the person-centered service planning process and people's rights. So just a quick, some definitions that you'll likely hear me use. I'll try to be mindful and actually say things like person-centered service plan, but if I refer to the PCSP, that's, you know, what I'm talking about. CHC, of course, is Community Health Choices. When I refer to CHC Plan, I'm talking about one of the 3 managed care organizations that's responsible for providing people the services they may be eligible for under Community Health Choices. CNA is the Comprehensive Needs Assessment. The specific tool the state uses, state requires the plans to use is called the Inter-I Home Care Assessment. We're going to talk about that a bit today. SC is the service coordinator, an important role for folks getting the home and community-based waiver services. And we're going to talk some about personal assistance services, or what I might refer to as PAS. Okay, so we're going to start with just a brief review of what Community Health Choices is. And, you know, just so folks, we can try to, if everybody listening today doesn't, you know, have a total sense of what Community Health Choices is, you know, in the phase 3 counties of the state, it launched in January of this year. So let's just cover a few basics, so hopefully get everybody, you know, on the same page. So what's Community Health Choices? Well, it's the name that the State Office of Long-Term Living gave to a new Medicaid service delivery for adults in Pennsylvania. So for a target population, and there are 3 groups of people who are in Community Health Choices. And as the second bullet indicates, it's a mandatory managed care program for those people in Pennsylvania on Medicaid that fall into the target population. Those 3 groups of people are individuals with both Medicare and Medicaid, with some exceptions, people who are in nursing homes, and Medicaid is paying for their nursing home care, and people who are receiving home and community-based waiver services that had been previously managed directly by the Office of Long-Term Living. So the state is now fully implemented with Community Health Choices. Obviously, as people become eligible, you know, for waiver services or become a dual eligible, they will, you know, join Community Health Choices. But the program is now, as of January of this year, implemented statewide. The state implemented the program in phases. And so once people are enrolled in Community Health Choices, those managed care plans, those 3 CHC plans, are responsible for the Medicaid physical health coverage for that individual, that responsible for their nursing home services. So if the person needs, be it short-term or ongoing nursing home care, and they're in Community Health Choices, it's the plan's responsibility to pay for those services. And if an individual in Community Health Choices is determined, has already been, or might be determined eligible for the home and community-based waiver services, they are then enrolled in CHC, and the CHC plan is responsible for paying for those services. Okay, so as I said, the state, specifically the Office of Long-Term Living, you know, rolled CHC out in phases. We're now, January 2020 was the final phase for what the state refers to as 3 different regions that make up a total of 48 counties: the Northeast region, the Northwest region, and the Lehigh Capital Zone. The choice of CHC managed care plans across the state are the same 3 plans. AmeriHealth Caritas, although in the Southeast, they call themselves Keystone First, but they are in fact the same plan, the same company. Pennsylvania Health and Wellness, and UPMC, Community Health Choices. And so individuals do have a choice of a plan, and they're allowed to change plans, and they can change plans at any point throughout the year. In terms of eligibility for home and community-based waiver services, that application process, how somebody becomes eligible to then get those services and paid for through one of the 3 CHC plans, that process has not changed. So nothing about Community Health Choices changed how somebody potentially becomes eligible or how somebody applies. People are still dealing with the independent enrollment broker, and that in Pennsylvania is Maximus. That's still the first place people go and call, and Maximus is still the entity that is, walking people through what they have to do in the application process to potentially be eligible to get home and community-based services. So that nothing about CHC changed that waiver application process. What CHC changes is once somebody's approved for the waiver, then who's paying for the services, who's authorizing or potentially denying requested services, who's coordinating the care that you're getting. Once you're found eligible, that's what changes under CHC, and that's where the CHC managed care plans step in and in essence take over. Okay, so let's talk a little bit more, kind of get into the meat, I think, of the presentation today. So can the CHC plan change somebody's waiver services? Well, they can now. The rule as CHC was rolled out in each of the 3 regions and over, each of the 3 zones over the past 3 years, beginning in January of 2018. When implementation started in each zone, for the first 6 months of implementation, the CHC plans could not change somebody's waiver services. They couldn't reduce the services they were getting prior to moving into the CHC system. They could not change the providers that were providing the services, the home and community-based services that individuals were receiving as they moved into CHC for 6 months. So that 6 months ended June 30th, and beginning July 1st, then the CHC plans can make changes, and they will require and do require that the service providers, the providers providing people the in-home services, are in the network of the plan, of the individual's plan. And now the plans can change an individual service, reduce them, substitute them for something else, terminate them altogether, effective July 1. But they cannot do that without first doing an assessment and completing a person-centered service plan. And if in fact, after that process, the plan decides to change, reduce, change, terminate services, then individuals have a right to appeal. And we're going to talk a lot more about the appeal process. Okay, so we're going to start with the person-centered service plan because the plan and the planning process is to be central in determining what are somebody's needs, what are their goals, and what services and supports specifically paid for through the CHC plan does somebody need in order to meet their goals. From our experience, really from our clients' experiences, the plans, all 3 of them, are still struggling with getting this person-centered service planning process right. And that's an important reason why we're highlighting it today, because the more people getting services, the more people, helping those getting services, advocating for them, perhaps even providing the services as service providers, the more who understand how this is supposed to work, hopefully the better chance of improvements in the system as it's working currently. Okay, so again, what's the purpose of the person-centered service planning process and the actual plan, which is a written document itself, determine somebody's service needs, and it should look at the entirety of somebody's needs, not just what is it I need from the plan to pay for. It should be looking at all of the person's needs and then determining what needs can or are being met by a neighbor or by a spouse or whoever, versus the needs that perhaps the plan has to provide. And the plan is to be assisting the participant to develop a holistic vision of their life, by identifying goals and outcomes. And then again, tied to, if I have goals, do I need certain supports in order to reach those goals? And the goals can be anything from, I want to go back to work to, it's important for me to get to church or to some religious service every week. And that should be included in my plan. Okay, so who develops this? Who's a part of this person-centered service planning process? Well, the participant, of course. In situations where the participant may not be able to participate, perhaps because of cognitive challenges, then it's hopefully someone that is a trusted family member, friend, spouse, adult child, sibling, and any number of people that could be a part of this planning process with or on behalf of the participant themselves. The service coordinator, key. This is who helps the individual and anybody else the individual wants a part of the plan to develop the plan. So service coordinator role is essential here, and it doesn't happen without the service coordinator. But more importantly, it should not be happening without the participant and anybody else the participant says, I want to be a part of this process for me. So that planning team is, the service coordinator for sure, the participant or somebody who is acting on their behalf, and then anybody else that participant wants to be a part of the process. Okay. So one of the ways, an important way, but not the only piece of developing the person-centered service plan is starting with a comprehensive needs assessment. As I said earlier, the specific tool that each of the plans are required by the Office of Long-Term Living to use is called the Inter-I Home Care Assessment. So the assessment is to be completed by the service coordinator, with the exception of COVID, that is, kind of turning everybody's world upside down. That assessment is always to be in person. Since March, they have, and through June and even into July, they were all being done by phone. The plans are now starting to, some more aggressively than others, get back into doing in-home assessments when the participant feels safe and comfortable. It is not required if the participant is feeling uncomfortable because of COVID. So normally it always has to be an in-home face-to-face assessment. COVID, of course, has changed that. The Inter-I itself, it's a very detailed, evaluation. Looks at kind of all aspects of people's health and functioning, looks at social emotional, looks at, looks at behavioral, and certainly just people's overall functioning, their ability to take care of their basic needs around bathing, dressing, toileting, mobility, and looking at beyond those activities of daily living, and including, help that people may need with financing, with shopping, with laundry, all those other kinds of things. The assessment should be looking at, somebody's need for supervision, either because of, physical, perhaps frailty, or because of cognitive reasons, somebody with perhaps a dementia or an Alzheimer's diagnosis. Should be looking at the risks to somebody's health, their safety, or their independence. And again, it should be looking at, are there, and who are they, if there are, able and willing supports, informal supports, or the plans typically refer to them as. I'm sorry, I'm going to get a drink. And again, should be looking at, preferences for community engagement. Should not just be looking at, well, do I need help with bathing and dressing? Do I need help with cooking and cleaning and laundry? Those areas, of course, are very important, but also should be looking at, again, the whole person. And again, we know COVID has impacted, a whole lot of community engagement. But beyond COVID, pre-COVID, and hopefully we all see beyond COVID, and even with COVID, people are still getting into the community to the extent that they feel safe and comfortable. That community engagement is an important part of that assessment. What brings meaning to people's life? What is it that they want to be doing, with in the community, getting to the library, visiting my cousin, my grandchildren, whatever it might be, and include, when interested, employment goals, education goals, interest in volunteering activity. The assessment should look at all of these things, a holistic, whole person approach, with the consumer, the participant, or, and or their, their designee leading this conversation and leading what will then be the development of the person-centered service plan. So within that written person-centered service plan itself, your goals are really important, and they're important for two overarching reasons. One, because they're your goals. And so you as the participant should be well informed by the service coordinator that this is your plan about your needs, preferences, and goals. And we need to hear from you or your designee about, what those goals are. The goals are also important because they should be written in to the service plan, not just the goals, but any objectives or things needed to meet those goals, and written into your service plan, so that if there's a problem and the plan decides, the CHC plan decides not to approve some service, you have that person-centered service plan to say, like, well, wait a minute, this is the whole purpose of the program. This is a big piece of the CHC plan's responsibility to assist me where I need assistance, to meet these goals. So, if one of my goals is to get to the library twice a month, but I can't get there without a personal assistant services, or I can't get there without transportation, what's referred to as, in terms of a benefit, as non-medical transportation, then I'm not going to be able to reach those goals. And so again, it's so important that people are involved in developing the person-centered service plan, stating their needs, preferences, and goals, making sure they're written into that plan, and knowing that that plan is, not a one and done. It should be seen as a living, breathing document because, of course, we change. Things change. Our situation changes. Our needs or our goals can change. And so then we should be going back to the plan, looking at what's in it, looking at what might need to be added to the plan, and then looking at, do I need any services to support that now perhaps I want to look at working, or I want to go to school or go back to school. So the plan and the goals and what I need to achieve my goals is really critical. People should always have a copy of their person-centered service plan. We talk to people repeatedly who either don't know what it is, don't know what we're referring to, or don't have a copy of it. That's hugely problematic. It's a person-centered service plan. The person is the participant. It is not supposed to sit in a computer somewhere, in an office somewhere with one of the CHC plans. Not the point of the plan. So again, the assessment is done, and from that assessment, then the participant or their designee and anybody else they want to be a part of this process is then working on, goals and what needs might I have to achieve those goals. The service coordinator must consider in working with the participant to develop the person-centered service plan, information, of course, provided by you or your designee, you the participant or your designee, and anybody, again, else that has information, whether verbal or written, that could be helpful. So that might be your caregivers, your family, doctors. There might be, depending on what the goal is or the need. Perhaps one of my goals is to be able to get up and down my stairs safely in my home. And that may require, a stair lift or chair lift. And perhaps, that's already been discussed with my doctor, or my doctor's willing to put that in writing and corroborate that absolutely my patient cannot safely navigate their stairs. Therefore, they need to have a stair lift. It's not required for most services that you have a doctor's letter or a doctor's letter of medical necessity, but it's certainly appropriate if the doctor's willing and helps to speak to, why in fact you need what you're saying, you need. This plan itself should not rely just on the functional assessment, the inter-I, that comprehensive needs assessment, or any other assessment tools or forms that each of the plans may be using. And some of them are using, assessments beyond the inter-I. But again, you cannot define a person by a checklist of questions. It needs to be a conversation in conjunction with that assessment that then should develop, person's goals, their needs, and ultimately then in a written person-centered service plan. Okay. So just some examples of inadequate planning. These are not examples we made up. These are examples we encounter and really have for what is almost now 3 years since Community HealthChoices started out in Southwest PA in January of 2018. So, for starters, that the service coordinator doesn't even explain the person-centered planning process, so that when they get to us perhaps with an issue and we're asking them about their plan, they're not knowing what we're talking about. Clearly, right out of the gate, that's a big problem. If the service coordinator, is not sitting down and explaining to people the whole point of the assessment and of developing the service plan. If the service coordinator focuses just, again, on, have one and doesn't talk about needs and goals. If the service, coordinator in the assessment is just looking at, okay, you need help with bathing, dressing, laundry, cooking, cleaning, as if that's all that, makes up our life. there's more to us and there's more to our lives than that. It should not focus on just those things. A service coordinator should never refuse to include any goals or requested services that you're stating and that you want included in your person-centered service plan, and shouldn't be saying things like, well, that won't ever get approved, or you can't ask for that many hours. You know, the plan's going to think you need to be in a nursing home if you need 24/7 care, or you can't ask for more than one home modification at a time. None of those things are true. None of those things should be being said to a participant by a service coordinator or anybody else, in particular, any representative from the Community Health Choices plan. And again, not relying on just the functional assessment tools and person-centered service plans that don't include people's goals, where there's goals on there, and then we talk to the participant and they say, I don't even know where those goals came from. Those weren't articulated by me. All of those are, and unfortunately there are many more examples, but these are some of perhaps the more common ones that we see, at least through our clients. This is inadequate planning. This is not how that process is supposed to work. Okay, so some tips for how should the person-centered service planning process work? Well, Pennsylvania Health Law Project, in conjunction and primarily driven by CHC participants, have developed a person-centered service planning toolkit. You can find it on our website. Kayla is also going to kindly email it to you at the end of the webinar. People have any questions about that, please reach out to me directly. Go back to that first slide where you have my direct email, my direct phone number. The toolkit is lengthy and perhaps on first glance could look really overwhelming and thinking, how's this going to be helpful? This is, you know, whatever it is, 20 pages long. But it really, you know, kind of works section by section. People don't need to kind of pour through it all at once. One of the features of the toolkit is listing every waiver service covered by the CHC waiver and a brief definition of those waiver services. Because again, we talk to folks all the time who say, well, I didn't know I could get help with transportation to go to bowling or bingo or church. You know, I didn't even know that I could get a modification to my bathroom so that it's safer and more accessible to me. So it lists every service that's potentially available. It is available based on person's needs and a brief definition. Again, ask for loved ones to be a part of this process. If your service coordinator is coming out to meet with you or calling by phone and you want others to be a part of that conversation, let them know. Then we need to schedule this around a time when, you know, my sister can be here or my caregiver can be here because that's what's important to you. Try to make a checklist of your goals and concerns. And again, if you go back to our person-centered service planning toolkit, I think there's an outline in there, kind of a guide to help people think about those things and break it even into areas and then work with the areas that might be appropriate. If you don't have goals around employment, then don't worry about that section, or goals around education, you know, because you're 80 and you're not concerned about either of those things, then just ignore those sections. Read, make sure you know the plan's being developed, that you read what's written into your plan, that you don't sign that plan without reading it. Oftentimes the service coordinators are, you know, working off of, you know, laptops and iPads, and, you know, that's fine. That might be the way of the world, but you know, you certainly can say, I don't really want to sign this laptop or this iPad. Like, I really want a copy, a written paper copy, or electronic, if that's what works for you. But I want to have the whole plan and carefully review it before I sign it, or before I, you know, say I'm not going to sign it because it doesn't include the goals that I want. And so you ask the service coordinator and insist that what you're identifying as a goal or a need is included in that plan. And again, be sure to have a copy of it. It should be dated. It should be current when any changes might be made to it. And if in fact there are not things in that plan that need to be, then you can appeal, and we're going to talk about that more later. Okay, so what if my needs change? So an assessment or a new assessment, a reassessment, if you've already had one done, can occur for many different reasons. For starters, and perhaps first and most importantly, a new assessment can happen anytime a participant requests a new assessment. So perhaps things are changing with your needs, changing with the people who are, your informal supports. You're living with a spouse, and now the spouse was relatively healthy and now they're not doing well. Any number of things that could change that could then, indicate to you, I'm going to need more help here now. And in order for that to happen, a new assessment has to be done. At any point, the participant has a right to request that. The plans are also required at a minimum to do an annual assessment, so once a year. Our experience with clients, the plans are doing these reassessments much more frequently, more like every 3 to 6 months. Again, outside of COVID's kind of turned everything upside down. A new assessment is required for the plans to do after any trigger event. And the trigger event is a significant change in your health or functioning, a change in your caregiver availability, back to that example of, my spouse was helping me and now my spouse is not well, or whatever the situation might be, and after a hospitalization. So in those situations, the plans are required to do a new assessment. And again, anything changes for the individual outside of even these required triggering events, triggering a new assessment to be done. People can be reaching out to their service coordinator, can't get them, then get to their supervisor, can't get that supervisor, get to their supervisor, until you reach who you need to reach to say, I need to have a new assessment done. Okay. People having problems with this process, as I've just described it, we want to hear about those. So please reach out to us. Call our helpline Monday, Wednesday, Friday, 8 to 8. Email us, send us a fax. Again, we're concerned about this process. We're concerned that this process continues to not operate as it's supposed to. And so if people are having problems, please feel free to reach out to us. Okay. So what if my plan does change my service? And again, for people now in the phase 3, 48 counties, the plans as of July 1 were able to start doing that after doing a new assessment and a new service plan. So you have rights, and we're going to talk about each of these in terms of continuity of care, if they're trying to reduce a service that you've been getting, right to a notice if they're going to make changes, and appeal rights that are included in that notice. Okay, so I think this piece I've said more than once. Starting July 1st in the 48 phase 3 counties, the plans are permitted to make changes, not without first completing the comprehensive needs assessment, the inter-I, and developing a new person-centered service plan. If your service coordinator calls you, because right now and until we come out of the other side of COVID, it's still the potential that these assessments could be done by phone. But if your service coordinator calls and it, maybe just feels like a check-in call, or they're just asking you some questions, you know, if it's not clear to you, if they're actually conducting the assessment and not just asking some check-in questions, ask them. I've talked to at least 1 or 2 people who had an assessment done and didn't know it was an assessment. That's not okay. That's not how this should work. So don't hesitate to ask. You know, are you calling just to check in, or is this an actual assessment? Because if it's an assessment, you want to be clear about that, and you want to make sure, you know, or if it's a bad time for that assessment, tell the service coordinator, I can't do this right now, or I don't want this done without my, you know, brother here, or without my spouse here. Let's reschedule this. When can you call back to do this? It needs to be based around you, and not, you know, because it was just a good time on the service coordinator's calendar to get your assessment done. But they are required to be doing these assessments. They're allowed to do them, but they cannot make changes. And your service coordinator should be letting you know that if an assessment is being done, anytime assessment's being done, it means there's a possibility there could be a change to your services. And service coordinators should always be advising people of that. If an assessment is done and a new person-centered service plan is completed, and the result of that is the plan thinks there needs to be some change to your service, reducing, terminating, replacing one service with another, you are entitled and must receive a written notice with 10 days advance written notice, so that they cannot send you, you know, a notice dated today, September 17th, and, you know, mail it, and you get it days and days later that says your services were changed effective today, September 17th. They're not permitted to do that. So it's really, really important that people are reading or having their mail, you know, gotten for them, whatever's working or the need is for the participant, that you're opening and reading any information from the CHC plan right away. Keep the notice and keep the envelope that it comes in. That's because we're seeing problems with plans writing and dating a notice, you know, September 1st and not mailing it based on the postmark until September 4th. And then people aren't getting it, you know, until September 9th. And it's telling them that their services are changing September 10th. It shouldn't be happening that way. So it's really helpful. Hold on to the notice, even keep the envelope that it came in. If you don't understand the notice, reach out to somebody, your service coordinator or somebody you trust, to, you know, see if they can help you parse through what it's saying. If you want any written communication from the plan to be sent to somebody in addition to yourself, you can tell the plan that. Tell them you want, you know, to add an additional addressee, so that any written communication from the plan also gets mailed to, you know, that trusted individual that you've identified. Okay, the notice, again, must give explanation in detail. So it shouldn't say, as the examples below, you know, yes, your assessment was done on such and such a date by your service coordinator based on that assessment and other information, et cetera, et cetera. We have determined that the 70 hours a week of personal assistance services you've been receiving are not medically necessary, and now we're approving 40 hours. And that's all the notice says. And then it goes on to tell you your appeal rights. That's not an adequate notice. You still want to appeal that immediately, but you also want to contact the plan to say, this notice is telling me nothing. I'm entitled to a notice per the state's requirements that explains to me and doesn't just say things like, it's not medically necessary. We don't even know what that means just in and of itself. Or it says you were assessed as needing fewer hours. You know, you didn't think so. What do you mean they were just assessed as needing few hours? Let the plan know and let us know. We want to hear about inadequate notices. In the beginning of CHC, there were really, really poor notices. Are they good now? Not necessarily good, but they're at least improved. We still want to hear about notices that aren't telling people anything helpful or meaningful. But in any case, the first thing you want to do if you don't agree with what's in that decision is appeal it. Okay. The notice should be in language that you understand or in a format you need. However, the plan, you need to let the plan know that. So if you are Spanish speaking, Spanish reading only, you do need to inform the plan that all the communication needs to come to me in Spanish. Then it comes in Spanish, great. If it doesn't come in Spanish, then you contact the plan and say, whatever's on this notice doesn't even matter or count because I can't read it. You need to send me one in Spanish. And then the notice, is effective. Same with needing something, in large print or some kind of alternative format. Let the plan know. Make sure your service coordinator knows as well. The more people, the better. And then you can let them know this did not come in a way I can read it or understand it. So therefore, it's not an effective notice. I'm going to pause here, check in with Kayla and see if we have any questions that have come in.
Yes, we have a few questions. So while we're answering that, if folks have more questions, just feel free to drop them into the Q&A section at the bottom of your screen. The first thing I just want to address, a couple of people have asked this, the PowerPoint will also be sent out after the webinar, so you can refer to that or print it out or do whatever, whatever helps you learn this info. So yes, that will be sent out. And then Tracy asks, does the assessment have to be in person? I have heard it has been by phone in anywhere from 4.5 to 8 hours long, and patients cannot and should not do that alone or via phone because it's too long.
Well, again, and I think I touched on this earlier, outside of COVID, yes, the assessment always has to be in person. Now, of course, we're still dealing with COVID. So from March on, and for many months, the state told the plans do not do assessments in person, and actually told the plans for many months only do an assessment that's required or being requested. They otherwise were not permitted to change or reduce services for many months, from March into June. Now the plans are allowed to start doing assessments. They are allowed to do them in home. Again, people can say if they are comfortable or not, or even just specify what kind of an arrangement. You can ask the service coordinator to bring their own folding chair. And of course, just come in, sit, stay there, and you'll keep 6 or more feet away. But otherwise, the assessments can be done by phone, and the plan will do them by phone if the individual is saying that they are not comfortable with in person. The assessment shouldn't ever be taking 4 to 8 hours. I mean, I guess it could. It should never be done in one stretch like that, by phone or even in person if the person's feeling like, wow, this is just way too much, or physically just not able to withstand that. So again, people have the right, and we encourage them, to speak up, to say to the service coordinator on the phone, are we almost done? Because I can't hold the phone any longer. I can't sit, and whatever it might be, and because if we're not already almost done, we need to schedule time to finish this. And I have heard from clients that service coordinators are doing them sometimes in 2 parts. The service coordinators are actually been encouraged by the state to call the participant, again, let them know I need to do an assessment. Is today even a good time to get started? And perhaps try to get, some pieces of the assessment done by phone, if in fact the participant's in agreement with, then the service coordinator coming out to complete the rest of it, in person. But yeah, assessment should not be 4 to 8 hours, and nobody should be expected to, in person or on the phone, be doing an assessment that long. And again, folks, I encourage them and all of you to encourage those you may be working with or for, speak up, tell them you cannot be on this phone. If 45 minutes is too long, it's too long. It is what it is. Then they have to call back. Thanks, Tracy, for that question.
Okay, Beth asks, since as of July 1st, CHC can change and/or disenroll a beneficiary, I assume nothing can be changed until the PCSP session happens. If there is a delay in getting this PCSP done, should we assume the benefits continue as they are presently? Is there some sort of deadline to get the PCSP done?
Okay, there were actually several questions, I think, in that question. First of all, the plan shouldn't be, generally should not be determining, that somebody is, no longer even eligible for the services, although I guess that is part of their role. So there is not, let me think about this. Is there a time frame from the person-centered service plan? Yes, it has to be developed within 30 days of the assessment. But there is to be no change to services without the assessment being completed in its entirety and the person-centered service plan being developed. And that individual should have a copy of it and obviously be a part of developing that plan. So right, nothing should change until both of those things are done and a written notice, advanced written notice, is received by the participant. So yes, everybody should be assuming nothing changes until assessment done, person-centered service plan is done, and if in fact that's yielding what the plan thinks needs to be a change, a written notice.
Okay, Pam asks, I have a client that just started her waiver services in August. Does she have 6 months until any changes can be made, or as of July 1st, anyone can have changes made by the by the CHC plan?
If they just became waiver eligible in August, they should have, based on the required timeframes for the assessment, that assessment's required to be done within the first 5 days that your client any client becomes eligible for the waiver services. So the assessment has hopefully already been completed. Feel free to reach out to me if that hasn't happened. And so, in that case, if the assessment's been done, the person-centered service plan is completed, and services have been put in place, then there's not any reason to think that person's going to have a reassessment, anytime soon. But again, they're only now required to do them once a year, and of course required with any triggering event. But the plans are absolutely doing them more often, more like every 3 to 6 months. But somebody who just became eligible in August, if in fact it's all completed and their services are in place, no, they should not be having a reassessment anytime too soon.
Okay, Natalia asks, what can we do as a provider of PAS services in order to gain these service plans when service coordinators from MCOs are not providing the service plan or uploading it into the client's profile, and reaching out to the MCO is not effective?
I've had this question once before, and I honestly, I'm not clear that the provider, that the PAS provider is entitled to access to the participant's entire plan. Perhaps with the written permission from the participant, then the PAS provider could have access to it. But otherwise, I don't know that the provider is entitled to access to the participant's entire plan. They certainly are entitled to know, what, in the case of PAS, if this individual's been authorized and your particular agency is authorized to provide X number of hours a week, then of course the provider needs to know that. But I really don't think there's a reason why the provider of one particular service is entitled to see somebody's entire plan. Because there's lots of other things that could be included in that plan that really don't have anything to do with you as the PAS provider. Other goals that I have, other services I need to meet those goals. Those, again, I don't know that the PAS provider needs that information, or certainly I don't know that they're entitled to get it. They just need to know what they need to know about their piece of it, and in this case, the PAS services. And the authorization should be, in the system for those.
Okay, and then we have some follow-up questions and comments for the question that you just answered, Janice. Catherine asked, then how, as a PAS provider, do we get audited on providing appropriate services? Shirley also adds to that by saying we need this information to provide the care. And Arati asks, how do you expect that client's person-centered goal would be achieved without knowing the plan and the goals?
And yeah, I mean, they're good questions. And maybe I'm off on this. Maybe, a particular provider, is entitled to see the whole plan, but I don't know that that's the case. But I think those are certainly questions that they're really much more provider questions that if they're not getting answered by the plans that you're dealing with, then I would go to the OLTL provider line and call the Office of Long-Term Living to get clear about that. Again, as the provider of any given service, you certainly need to know what services and the amount of services, are being authorized, so that, you're providing what's authorized, no more, no less. But I don't know that you're, again, really have a right to the entire plan. But again, I absolutely defer to the plans, and in particular OLTL, and to call that OLTL provider line.
Okay, Susan asks, with the mail slowdown, has the 10 days notice been subject to change?
Excellent question. We have raised that with the state, and actually not just with the Office of Long-Term Living, being that the notice and the 10-day timeline applies across Medicaid managed care systems. So that's Community Health Choices, Physical Health Choices, Behavioral Health Choices. And we have recently raised this to all those state officials, requesting that at least be expanded to 15 days. And that is currently at the state level being considered. So, yep, great question. But for the time being, then, it's why it's so important people read the notices, or hopefully have somebody available timely enough to read their notice for them, that they keep the notice, that they keep the envelope. Because if there's, a problem, as we saw and are still seeing sometimes, the date, notice is dated by the plan September 1, the mail date is until the 4th, person doesn't receive it out of, in the case of Pennsylvania Health and Wellness, it seems like it comes out of their St. Louis office, and I didn't get it till the 9th, and now I'm already at day 9. You want to call the plan and call us if you're seeing those problems. But yes, we hope to see that. Stay tuned for, will that 10 days be expanded to 15? Kayla, can we just take one more? And I
Absolutely.
just because I love the questions, and I am fine. I can't speak for Kayla, but I'm fine to stay beyond 11:30, but trying to be mindful of what people expected and just trying to get through the rest of the slides.
Sure.
Good problem to have, folks. I appreciate the questions.
Yeah, we'll do one more right now. Tracy asks, can the letter state, your PAS hours are being changed because your assessment showed that your personal assistance needs can be met with 18 hours of PAS per week?
Do we think it's adequate? We, the Health Law Project, and perhaps other advocates, no. Right now, does OLTL seem to think that that's adequate? Yes. We keep pushing on these. We don't think that's really sufficient, but I do believe at this point that OLTL would not see that as a problematic notice. Good questions, folks. Okay, keep sending them in again, and folks, if we run out of time, please call me or email me. Okay, so what about the appeal process? How do I appeal? Okay, so my first appeal option is a grievance. A grievance is an appeal of the plan's decision after receiving in writing to reduce, suspend, or terminate services or change them. Any denial of something that was requested, a service or an item. They deny what you asked for but approve something different. Or the service coordinator not including something that you specifically identified as a goal and a needed service, and didn't put it in your service plan. In terms of a tip here at the bottom, it is helpful for the participant to be clear what was submitted by the service coordinator. So if that's not clear at the end of the assessment and the development of the person-centered service plan, and it should be ideally because you should have a copy of it and know exactly what's in that plan and the specific services asked for, or the specific number of services in the case of something like the personal assistance services. But again, I've talked to somebody as recently as in the past week or two. Well, what was their request? How many hours? They weren't clear. Service coordinator said one thing and then another. That's not how this should work. And participants, again, should not hesitate to ask, well, what exactly was submitted, and ideally should know because they've got a copy in their hand. Okay, so who can request the grievance? Of course, the CHC participant. If the CHC participant has a power of attorney or a guardian, but very important that the CHC plan has a copy of those documents. Unfortunately, it's not enough for me to call and try to request a grievance for my father saying, I'm his POA. Unfortunately, the plan doesn't have to take my word for that. They should have a copy, and it's important to get those documents to the plan. It helps also, if you can, to even jot down, I mailed it to them, or I emailed it to them, or faxed it to them, and when you did that. Because unfortunately, we come across situations where people did send these documents, the plans are still saying they don't have them. A provider or somebody else with the written permission of the CHC participant can request the grievance. And the forms that are included should be included with the notices. Actually, say on there, is there somebody else you want to request this for you or represent you? And you can put that in writing. How do I request the grievance? Phone, mail, facts. And again, the notice should tell me all of that. The notice should include a form to file the grievance. It should, if people do it, if people need help filing the grievance, they should call the plan and tell them, I have to file a grievance. I'm not sure how to do this. I need help doing it. And the plan should be helping. If you do or somebody on your behalf requests the grievance, if you can, or somebody on your behalf is able, it's really helpful to ask for the name of the person that you called when you called to request the grievance, the date and time that you called. And you can ask them if there's some reference number, or maybe they call it an identification number for the phone call. These calls, to my knowledge, are all recorded. And so they should have some kind of reference number attached to the call itself. Very helpful if the participant or somebody who's doing it on their behalf can get that specific information. Really helps when you can then go back to the plan and say, absolutely, I called to request this grievance. It was Thursday, September 17th at 11:11 a.m. and I spoke with Joanna. And she gave me a reference number, and here it is. So to the extent people are able to do that, it's really helpful. If people request it by fax or by mail, it certainly doesn't hurt to follow up with a call to see if that was received. Again, if people are able, or have somebody able to do it on their behalf. Okay. So what do I include in the grievance request? And the form asks for all these things, that you want to file a grievance. What decision you're appealing. So it's the notice that I received that's dated, September 15th. Why you disagree with the decision. All you need to put on that line is, because what was approved is not what I asked for, or what was approved won't meet my needs. You're not making your argument on that form. You're just requesting the appeal to get the opportunity to then make your argument. So that, can just be a couple words. If in fact the plan's reducing services that you're getting, you can include on the form that I want my services to stay the same because I'm in fact appealing this within 10 days, which it currently is that time frame, and I want my services to continue while the appeal process plays out. Indicate whether I want the grievance by phone or in person. Again, at this point, I think they're all by phone because of COVID. People can request a video conference if they have the video capability. You can ask for, and we really encourage and advise people to do this, for all the information the plan used to make their decision to change or reduce or terminate your services. So that information, certainly can include and should include that assessment, that inter-I or comprehensive needs assessment, the person-centered service plan that you shouldn't have to request because you should already have a copy of, but nonetheless, I'd ask just to make sure they match up. And any time and task tool, the plans, and they all use them to basically calculate the hours they think I need in the case of denial of PAS services. Any other notes, any policies that the plan used to make their decision. The notice tells you can ask for those things. It tells you you're entitled to them. And we encourage people to ask for that information. And then if in fact you want somebody to represent you, who that person would be, include that in the form or include that in the phone call. And then this is might be a little hard to read, small print, but this is just a sample of a complaint grievance request form that comes with a denial notice. And this one happens to be Pennsylvania Health and Wellness. I just happen to have a blank copy of theirs. So each of them may look a little bit different, but basically kind of asking for the same information. And it does ask things like number 4, do you need an interpreter? If in fact you need an interpreter, that's where you want to check it and indicate, the language that you need for purposes of the grievance itself. Okay. How long do I have to file the grievance? Well, there's 2 time frames to pay attention to. You have 60 days to file a grievance from that notice. However, again, if you're getting services and the plan is now trying to reduce the services that you're already getting, typically this is the case, with PAS services, you want to appeal that denial within 10 days at the date on the notice or prior to the effective date, because the notice should tell you an effective date based on the assessment, based on such and such. We've decided you don't need 70 hours a week of PAS, you only need 40, and effective September 25th, your services will be reduced. So, whichever day is more beneficial, if in fact you need, a little time, but, certainly from our perspective, when in doubt, appeal. Get the appeal on the record. You can always change your mind down the road and withdraw the request for the grievance. When in doubt, appeal, and people want to appeal as quickly as you can. And again, the date on that notice should be the same as the mail date. There shouldn't be, maybe there's a day difference if you want to give them a little benefit, but otherwise, there should not be days between the date on that notice and the postmark date. Okay. So what happens next? You filed the grievance. The plan is then required to send you, excuse me, a grievance acknowledgement letter. That acknowledgement letter, it should say, we received your grievance regarding, the denial of bathroom modification, denial of whatever it was, and the date that the plan received it. If it doesn't accurately describe what you're appealing or the reasons you're filing the grievance, call the plan right away and let them know. And again, notice tells you that, the grievance acknowledgement letter tells you that, if you requested the grievance within 10 days or prior to the effective date, then your services are going to continue. Then the individual should receive another letter from the plan. That letter is going to tell you the date and time of the grievance. And just to back up a second, the grievance acknowledgement letter, will also let people know if you want to participate in the grievance or somebody representing on your behalf, to call the plan and notify them that. And then, as I said, that final letter is the letter with the grievance date and time. So what happens at the grievance itself? And people are, again, have a right to and are encouraged to participate in the grievance. It'll happen with or without you, but not much tends to happen in your favor without you or somebody participating. The grievance committee is made up of 3 or more people. Typically, it always must include a doctor, and a doctor different than the doctor who made the original decision to change or reduce or terminate your services. Somebody else, usually a representative from the plan, and then the third person is typically what they consider like a community representative, somebody who doesn't work for the plan. Again, at this point, in person isn't happening. They could be by video conference, or it's just by a phone call, a conference phone call. Typically, it takes about 30 to 60 minutes. People should not be rushed or field rushed to present their information. The proceeding is required to be either recorded or transcribed. And you or your representative, in the case of the Health Law Project, we are your legal representative when you ask us and we agree to do that. Then, you present your case. Anybody else you want to participate who's willing and able, it, can be a part of that process and speak, on your behalf. You don't really have a right to kind of question the CHC plan with the information they present, but you certainly have a right to correct it. So, and typically the plan presents first and says, we're here today, this is a grievance for Janice Meinert regarding the denial of her personal assistance services. The request was X hours, the plan approved less than that, et cetera, et cetera. If the plan says something in that process that isn't correct, you certainly can, you can certainly correct that when you do your own presentation. So again, you've got a right to participate by phone, in person, when COVID allows that again, or by video conference. And of course, you have to let the plan know that you wish to participate. They don't know that otherwise. They should be providing a 15-day advance written notice of the grievance date and time. We're not always seeing that happen. If that's okay, if you only got 10 days notice and you're still all right and feel prepared, fine. Otherwise, you can call them and tell them you need to reschedule this. You have the opportunity to submit any additional documentation. So this might be the opportunity for, your doctor, perhaps, if the doctor agrees with whatever you're asking for and you medically need it. This is a good chance to ask the doctor to write that notice, and you can have that submitted to the plan so that the grievance panel has that before, at the grievance. Again, you can have somebody represent you. You can present, any evidence, arguments, witnesses, any information that you feel will be helpful to explaining why you need what you need and not something other than, what the plan approved. Okay. So what are you trying to show in terms of, making your case? You're trying to show that what you need is medically necessary, and that the plan made the wrong decision about what they think was or wasn't medically necessary. If there's been a problem with the process up until this point, you can also share that information at the grievance itself. Your notice came late, or you never even saw a person-centered service plan, much less know if you participated in it. Those kinds of procedural issues you can share at the grievance. But again, the focus really of the grievance is proving why you need what you need, the medical necessity of it. And so there is actually specific medical necessity criteria. And there are 4 prongs. We will get to the 4th. And so when you think about preparing, your argument or what you want to be telling the grievance committee, the panel, you want to think about what service am I trying to get that they're saying I don't need or don't need as much of, and why do I need it? Do I need this service because it's reasonably expected to prevent the onset of an illness, condition, or disability? That may or may not fit for your case. Only one of these needs to be, you only need to meet one prong of this medical necessity criteria. Is the service reasonably expected to reduce or ameliorate physical, mental, or developmental effects of an illness, condition, injury, or disability I already have? The reason I need the services. Will they assist me to achieve or maintain maximum functional capacity in performing daily activities? Or, and this one is often key in trying to get the in-home, the waiver services, will it provide the opportunity for me as the participant receiving the LTSS, the long-term services and supports, to have access to the benefits of community living to achieve person-centered goals and live and work in the setting of my choice? Again, back to that person-centered goals that hopefully has been articulated long before we get to this grievance and written down in my person-centered service plan. And that takes us back to the earlier part of the presentation. Why is the person-centered service planning process important? Why people should be educated on it and feel empowered about doing it, educated about it, and have it in writing and have a copy, so that if it now gets to this point with what I've identified as a goal and the needs or the services I have to reach these goals, that it's all spelled out in my plan. Very helpful then to be using that very plan to say, it's right here in this document. It was a part of what we discussed when, that yes, I do need non-medical transportation, because it's clearly spelled out in my goals that I want to get to the library twice a month and I have no way to get there and no other supports in the community. I need the help of the plan with non-medical transportation. Okay. So preparing for the grievance is, of course, very important. And when the Health Law Project, when we represent you in a grievance, these are all the kinds of things that we do. We're going to review all the documents. You hopefully ask for the plan to send you a copy of your assessment and your person-centered plan, all the information they use to make their decision. And then think about what it is you want to, what's most important to share, at the grievance. Kind of sketch out your argument, gather your evidence, perhaps that person-centered service plan, perhaps the very assessment they did that you now hopefully have a copy of that is either accurate and shows I do need maximum assistance with bathing or toileting or laundry, whatever it is. Or in fact, that assessment's not accurate. And you don't know how they got that answer, because you don't need minimal assistance with, laundry. You can't do laundry at all. You can't even carry the basket of laundry. So I need maximum assistance, and the assessment is inaccurate. That's some of the kinds of evidence you might be gathering. Witnesses, who's going to help, if anybody, to present your case. And then, proceed to present your case. This is not a hearing, it isn't a formal procedure, but so it's not, we're not advising people that you need to make it formal. These are just really some tips for, how to feel prepared to get on that call, or, or in, in the case when able to do this in person. Have your thoughts organized, have any, your doctor's letter there, or in this case, get to the plan beforehand, so the grievance panel has it in front of them. And again, remembering, this is about you. You know what you need, or certainly others who are able to speak, with you or for you. You're the expert here. This is your grievance. It's not the plan's grievance. They're required to do this. This is your grievance about you and your needs. So again, just kind of walking through, 1, 2, 3, 4 steps here, sketch out your argument. Why is the plan decision wrong? Why, they want to approve, you need a bathroom modification and they want to do a tub cut and you've asked for a walk-in shower. Explain then, why won't the tub cut work? Why is that problematic in your particular situation? Why does it have to be a walk-in shower? And again, going back to that medical necessity criteria, which one of those prongs, maybe more than one, does it meet, and tie it to that? And what, if any, witnesses or evidence you have to support it. Perhaps, family members who help you now get a bath, who can help explain with you why this one thing's going to not work and something else would. Again, any issues with the procedure that the plan had, you can tell them that at this point. Gather your evidence. We talked about this, a couple slides ago. Making sure you get everything the plan used to make the decision, and gathering any any of your own evidence. Again, witnesses who's maybe either going to represent you, speak with you, or for you. You are entitled to have people help you and explain what you need, why you need it, why it's medically necessary. Obviously, you're going to choose people that are knowledgeable about your situation, and people, of course, that you trust. If you need more time to prepare for the grievance, you're entitled to that to be rescheduled. Call the plan, let them know you're requesting it to be, at a later date and time. And then, go in there as prepared as you can, or the people who are doing this with you or for you, and, present your case. If you have documents to submit to the plan in advance, you're entitled to do that. You're either going to call just the plan number, or perhaps at this point you have a grievance coordinator that's been identified for your case, and you may have the name and direct phone number for the grievance coordinator to say, I have a letter from my doctor. How do I get this to you so that the grievance panel, has it? And then explain, your argument to the grievance panel. Explain why, the plan's assessment and then time task tool says, it only takes, 1.5 hours a week for you to bathe. And if that's way off, that the process takes more like 45 minutes a day, then walk the panel through that a bit. Sometimes your evidence or your argument is just you explaining to the person, here's what's involved in me being able to get a bath each day and, get myself clean head to toe. Here's how long this takes. It's 45 minutes a day. It's not an hour and a half a week. And just explain that to the plan. Again, witnesses to speak on your behalf, discuss any documents that you've submitted, and why they're important, and helpful to just, make yourself an outline or a checklist or bullet points, keywords, whatever works for you or the person doing this, with or for you, to make sure that you cover all the important points that you want to cover when you present your case to the panel. Okay. If you promise to send any additional materials to the panel, sometimes you can ask and let the panel know. I do have a letter from my doctor. It should be here today. Can I send it to you? They should tell you how to do that, and then make sure that you do that. And then when do I get a grievance decision? You're required to get it in writing. It shouldn't be any more than 30 days from the date back when I requested the grievance, either by mail or fax or phone. If you asked for the grievance to be extended, then the plan also has an extension, another 14 days to get you a decision. Typically, in our experience with clients, people receive that written decision within 7 to 10 days, I would say, of the grievance itself, the day that the grievance is heard. Okay. People also have a right to an expedited grievance. So when you first get that notice and, let's say it's a situation where you asked for an increase in, say, personal assistance services because you had somebody helping you, a non-paid family member, whoever, and now that person is no longer available. They moved, they're sick, whatever it might be. And so now I need more services. I need somebody to help me with the things that person was helping me with that's now no longer available. So I need more services, and I have an assessment done and request an increase in services. I get a notice saying, no, we don't think you need any more services. And I can't wait for this whole process to play out 30 days. Then you can request an expedited grievance, but then your doctor must put in writing why you can't wait the typical 30 days, and helpful if the doctor uses the language, that my patient's life, physical, mental health, ability to attain, maintain, or regain maximum functioning, whichever might be appropriate, would be placed in jeopardy by waiting the 30 days. And then the plan, if they accept the need for the expedited appeal, then the appeal itself and the decision should happen within either 48 hours of getting that note, the provider, the doctor's letter, or within 72 hours of when you called to request the expedited grievance. Okay. What if I lose my grievance? We're not going to get into the nuances of all of these. But even if you lose at the grievance, there are still 2 more appeal options. People can ask for a fair hearing. They can ask for an external review. They can ask for both. Generally, when in doubt, ask for both of them, because they're really giving you 2 chances to win. That's like 2 bites at the apple. You only have to win one or the other. You don't have to win them both. You don't have to, one's not more important than the other in terms of a final decision. They're both, final decisions. If if you win at the fair hearing, you win. If you win at the external review and the fair hearing hasn't even been scheduled yet, now you can withdraw the request for the fair hearing. In either case, that 10-day rule around getting benefits that the plan might be trying to change or reduce applies in both situations. So if you're appealing both the fair hearing and the external review, you need to request each of them separately and each of them within that 10-day time frame, so that I now have the opportunity to wait for both of these if they both have to play out, because I might get an external review decision not in my favor, but I appeal timely also for the fair hearing, and that's not even been scheduled yet. So I'm still getting my services continued until that appeal plays out. Okay. Again, I think hopefully I stressed a lot the importance of, the person-centered planning process. You, the participant, are the person in the person-centered service planning process. You're key, what you need, your goals, what you need to achieve those goals. And your goals may be that I'm 88 years old and my goal is to stay at home and safely have my needs taken care of at home. That, might be the crux of your goal. That's okay. Your goal is your goal. You do have rights and protections. We've gone through the important ones here today. We're here to help. Call us for advice. Call us if you're seeking representation, based on the merit of your case, based on the volume of the cases we have at any given time, determines whether we can actually represent you. At the very least, we can almost always provide you advice. Unless you're calling us an hour before the grievance, then that usually we're not going to be able to be too helpful. But please reach out to call us. Okay. Again, I apologize. I know we're past time. Kayla, do you have a couple more minutes?
Yes.
Okay. Do we have any more questions?
We have a few, yeah. So some people will be reaching out directly to you, Janice, via email with questions, which again is a great option for folks if we don't get to your question, or if right after the webinar something comes to mind. So feel free. You could either email me at event@phlp.org, and I'll make sure that Janice gets it, or you can email it to Janice directly. Okay, Pam asks, I am seeing that some plans are not authorizing both RN and LPN services for clients that require skilled nursing. They are approving either all RN or all LPN and not allowing us to reconcile. We were approved and passed both levels of care for PDN clients to ensure coverage. Is this something that they can do?
That's an excellent question. And Pam, if you would email me directly mainly just so I have your email and or your phone number. I feel like I've looked at this in the waiver and or the agreement in the past, but I am not positive of the answer to that, and I apologize off the top of my head. So please contact me and let me do a little research on that. Check the waiver language, check the agreement, and see what they say about this particular issue of RN versus the LPN.
Okay. Natalia asks, you had recently said 5 days for an assessment is supposed to take place after a client is approved. I've had clients that have been waiting for more than 3 weeks for an assessment. What are the next steps that they can take?
I would certainly have them call the plan and file a complaint with the plan. I would also encourage them, they certainly can call us. And I would also encourage them to call the Office of Long-Term Living, the OLTL participant line, because that is absolutely problematic. People should not be waiting 3 weeks. And in particular right now, where the plans still have the flexibility to be doing these by phone. So we don't even have to be dealing with, the time involved in the service coordinator's travel. They're still allowed to do these or can have the option to do these by phone. Yeah, nobody should be waiting 3 weeks. And that the Office of Long-Term Living participant line is, taped to my computer, 1-800-757-5042. 1-800-757-5042. And if you have the client's permission to give me, their name and date of birth, you can also just email me. Our helpline's not open again until tomorrow morning. Natalia, I'm sorry, was it Natalia who asked that question?
Yes.
Yeah. Yeah, with the client's permission, Natalia, feel free to email me. Client's name, date of birth, the plan, of course, which plan they're in. And I will certainly do my best to push it on this end.
Okay, I think this is the last question. Someone asked, earlier you said that the plan needs to provide 10 days notice for changes to a service plan. Does this 10 days include notice to the provider as well? I've been getting notice that hours have been drastically changed, usually reduced as of the next day.
Yeah, I don't know that the providers are entitled to 10-day advance notice. But again, please email me, jminert@phlp.org. And I'm glad to double check that. Our expertise always lies in terms of participants' rights, and very much less so regarding providers' rights. But please email me. I'm glad to try to take a look at that and see if there's any language in the agreement. It would be unlikely to be in the waiver, but it could be in the agreement if providers do have a right. It sure would be nice, I'm sure, for trying to figure out on your end. And if and when providers are able, if you get that notice on behalf of one of your clients, if you're able to reach out to the client as quickly as you can to say, hey, Janice, I got a notification from your plan that your, services are getting reduced. Did you get that notice too? And, if not, that's a big problem, of course, as we've talked through this morning. they want to contact the service coordinator of the plan immediately. And, you know, and if the client says, I got it, I got it like 4 days ago and I appealed. And so they appealed timely, then you then want to reach out to the plan to say, you know, if I'm correct now, these services are not reducing effective tomorrow because our client got a notice and appealed it timely. So they remain in place, right? Don't they? And in those cases, certainly either the provider or the participant, you know, the provider on the participant's behalf, with their permission, can call the Health Law Project. Because when people get the notices they should, appeal timely, as they hopefully get the opportunity to do, then there should be no reduction in the services till the appeal process is complete. Any other questions, folks? Please, please feel free. Reach out to me, call me, email me. I so appreciate all the questions and the interaction. I hope this was helpful for folks. The survey will be coming. If you can please complete that, I really, really appreciate it. And so does the Pennsylvania Developmental Disability Council. Everybody has to justify the dollars that flow from the Fed. So we appreciate if you can take a minute to fill out that survey. And then folks will get a copy of the PowerPoint, the survey, and a copy of the toolkit, the Person-Centered Service Planning Toolkit. Thank you so much. I really appreciate everybody's time and interest. Kayla, as always, can't do these without you. Thank you so much. Everybody enjoy the rest of their day, and please feel free to contact me. Thank you. Thanks, Kayla.
Great. Thanks, everyone. Have a good rest of your day.